You've reached FIT TV. Stick around. We'll be right back. Our purpose at FIT TV is to reverse the trends in our divorce culture. And we've decided, of course, that you can't adjudicate relationships, something we say on the program all the time. With that in mind, we have constitutional expert Leon Koziel, sorry, will help us to tie things up in a way today that will bring in his experience of lobbying and working with the constitutional aspects on the federal level to what we deal with on the state level. Welcome, Leon.
Pleasure to be here, Chris.
Changing the direction of our, just a quick comment on what we use as a comment of changing the direction of our divorce culture. This is what one of our purposes is. What does that mean to you?
Well, I think we definitely have to reverse the current trend because our country is on a collision course with disaster as we swallow up increasing segments of our population in these controversies in courts, this oppositional framework that we have under divorce law. And if we don't get this under control, we're going to see increased problems in terms of our productivity, our criminal statistics, the damage that's occurring to our healthcare institutions as a result of these controversies. And so it's not good for families. It's not good for the moral compass of our nation. It's not good from an individual standpoint, social standpoint. All our communities are adversely affected when people are in these courts fighting over custody and power and money awards.
Things that they own that they somehow appear to not be so good at anymore because the state has said so. Our audience wants to know, how did you get involved in the advocacy to begin with? Can you share us a little bit with it?
Yeah, years ago, as a lawyer, I stayed out of family court and divorce courts. I saw that making money off the split up of a marriage, to me, was immoral, something that I didn't go to law school for. However, when I became personally impacted by a system that I could already foresee how it was going to go, because they empower one parent over the other. You create unequal parenting roles. It violates the most fundamental principles of our Constitution. And then we allow one parent to tax and destroy the other parent. And it's not good for the children. It's not good for cooperative child rearing. And this oppositional framework is principally beneficial to lawyers and forensic people, you know, the therapists and the court-ordered folks that come in and tell us how to raise our children. The state is essentially becoming the super parent over all of us.
And the state can do that. They can come in and say, you know, you have to go out and get a psychological professional to help evaluate your custody ability. Am I right?
They believe they can do it. They've assumed power that they do not have. And in every given situation, the poor litigant is in there believing that they have this power, and so they succumb to it. Sometimes they do this out of fear, other times out of surrender, other times because the state actually gets them believing that they can't parent.
Yeah.
This is pathetic. We were all essentially given, it's a God-given thing, the ability to parent. And we have, in this country especially, what we are noted for more than anything else is our diversity. What we call, and it's been referred to in constitutional by scholars, is laboratories. We have individual laboratories around our country, all operating with diversity. We don't know who's got the best parenting philosophy, but we allow, in this country at least, parents to do what they do best, raise their children. And we are not going to be able to stand in judgment over our neighbor and say, well, you're not doing it my way, and so therefore you're wrong. And so the state believes it has this power, but it's up to us to say, no, you don't.
Right.
And we do this through the various checks and balances that we exercise in our Bill of Rights.
And you're going to, of course, apply constitutional thresholds. You're going to make something happen constitutionally on the federal level to try to make sure that we gain back, if possible, our power that we lost as
Absolutely,
parents.
Chris. The states' governments have gone, and with some assistance from the federal government, they know no boundaries. They are eroding every line of defense we have remaining, to the point where they're right in our homes, telling us how to raise our children with lawyers over our children. It is barbaric. What we do is we take two parents that, in my situation, we had separation agreements. We had modified them over a couple of years of separation, had no issues, no material ones. And even though the separated residential environment proved to be beneficial to our children, the state suddenly came in and said, well, we're not going to grant this divorce because you haven't given us your statements of net worth, you haven't complied, with certain aspects of Title 4D, that is to say the Child Support Standards Act, you haven't picked a superior and inferior parent, that is to say a custodial and non-custodial parent. And of course, the response was, well, we're not having any problems. There's no contest here. It's an uncontested divorce. Just sign it, and we'll be on our merry way. We've already proved that agreement's working, right?
Thank you
and
very
under
much.
the Contracts Clause of the Constitution, we're supposed to have that right to contract, to arrange agreements. And parenting functions best. Children are benefited the most when we have agreements between parents. But the state comes in and says, no, we know better how to raise your children. They infringe upon this right. They dismantle everything that may have been good or remaining in the parent-child relationships. And by creating this unequal parenting doctrine, as I call it, they violated the Constitution across the board. And so the lawsuits in federal government are a check and balance upon this power. And I think the Supreme Court has never squarely addressed this question. Have the states gone too far? And I'm talking about the whole myriad of things. They've taken out a case recently. The Supreme Court agreed to hear a case involving imprisoned child support obligers, imprisoned without counsel. I don't think it's a big deal, okay, because basically they're just going to bring more lawyers into the system. The bigger problem, the bigger question to be asked, is how do these child support obligers become indigent in the first place? Well, because we have, through this formula, essentially created deadbeat moms, deadbeat dads, money molesting moms, if you want to look at it from another parenting slur perspective.
I wrote an article called "The Manufactured Deadbeat" where I spell that out.
Okay.
They're manufacturing deadbeats.
Okay. And so they're promoting this because they leave the non-custodial parent unable to, when you get rid of the taxes, that they have to pay, their own basic, sustenance, the money they're paying out, they've got nothing left to live on. And so they become public charges. They become,
sure.
And even then they're not allowed to collect benefits because they're in arrears. And so it is really an unbelievably barbaric system. We place two parents in opposition to one another. We put them on a public stage in these public courtrooms, and we say, hey, let's go fight until you both just destroy one another.
And waste your money.
Sounds a little bit like something from the Roman Colosseum days, doesn't it?
It
We're
certainly
supposed to be a
does.
civilized society. It's a barbaric process, and it's time to end it.
Yeah.
And only the people can end it. That's what our government's about, folks.
Let's add to that particular scenario you just drew up and talk about legal representation. Now you're in this place where you've been depleted of your assets or you've been depleted of your income. You've become a manufactured award of the state. Now, how do you go forward and say, I think I'll hire an attorney now to get myself out of that, and will it help?
Well, I think that the conventional wisdom is that you should have competent counsel representing you because, you're going to be out.
Do you look under C for competency?
Well, it's relative, perhaps. But I don't know that, if you're standing in court and you have a lawyer on the other end walking circles around you with procedural nuances that you can't even begin to understand, try as you might, but though still simply because there's a lawyer on the other side, you're probably going to get beat up. However, I look at it from a different perspective, that if you go into it as a self-represented litigant might, at the very least, you'll be able to better evaluate the performance of the lawyer that you are paying for. And ultimately, if you're not successful, if you are, unfortunately, through the manner in which you were born or through some other unfortunate circumstance, you become the non-custodial parent, you may not be able to afford a lawyer. And so, as a result, you're going to need to know something about the system. And if you have the money, that may even be worse. Because, the first thing, remember I told you how I got started. They wanted to see the financial statements, okay? And from that, they can gauge just how much resources are available
and how long
to be
they
dissipated.
Prolong the case or whatever they want to do.
Exactly.
To you're
so
an
I don't know if
asset
I feel more sorry for the indigent guy or the wealthy person.
Right.
The fact is, even the wealthy person needs to understand that if you're going to get lawyers involved, okay, make sure they're doing their job and only limited to doing that job. Otherwise...
Which is a tough task for that pro se or that guy who's got that attorney, he's got money. Where does he gauge the success of each individual motion. It's a challenge within
I'm not
itself.
sure an attorney can gauge it, okay?
Right, yeah.
Because the attorney simply sees more money and says, you need aggressive representation.
Right.
And so we got to file this motion and that one,
Right.
and oh, well, we lost this one, but we won that one. Now we can appeal it. We can go here and the other thing. And then it's just about how much you can destroy the other parent. I had a woman that came into my life during my campaign. I ran for Congress and state senate, and she made a point to me. Well, how did you ever know about me? She goes, well, I called you once. Well, what for? Because I wanted to retain the most pit bull kind of lawyer I could find, and I knew you were the guy. You would destroy my ex-husband. I go, well, that's not what I do. And she goes, I know you don't, because when I did call your office a few years ago, you told me that you don't do divorces, and I was very disappointed. Now that sent a different kind of message. That told me that there are human beings out there that just get, whether it's through vendettas, maybe they were cheated on or whatever, but they get a certain kind of barbaric, sadistic satisfaction out of destroying the other parent of their own flesh and blood.
And there's a history of that.
This is something that I have yet to come to grips with. It's going on here in America.
Can I help you a little bit with
country
you?
that prides itself on civilized
Let me
behavior.
try to blend in a little bit here, because the only place I have a little bit of experience, let me throw it on you.
Okay.
The sociological patterns of our families have been deteriorated over time, and so has the information we've gotten from the transition of family, that a lawyer or a lawyer application at some point should be or could be, and it becomes evidentiary after a while. We see the pattern of people using lawyers. So once you have a lawyer in the family that's had a success in a divorce, he gets to be referred to that next person and so forth. A lot of people have that trouble. They cannot figure out whether they need to hire a lawyer or not, but they end up doing it that way, and I know I was one of those people. It didn't seem that I needed one, because it seemed fundamentally agreed, but when we did, as you're stating, we got messed up and lost a lot of money.
Well, I'd like to make this point. This is so important. I would ask every listener or viewer here to listen to this very carefully. There's a case out there called Tropia versus Tropia. I find it's fascinating because it's a High Court of New York opinion, which is about as high as it goes.
At a state case, did you say?
It's a state court case, sure. It's in Albany. Court of Appeals, the High Court of the state system in Albany. And since cases don't get to the United States Supreme Court, the Supreme Court hasn't ruled on any of these questions. The last one was a grandparents' rights case, okay, in the year 2000. And so they haven't dealt with moms and dads in this. They've deferred to the states. So here's the highest court, essentially in the land, in our state, if you happen to live here. And here's what they said. They evaluated, there were 2 non-custodial dads and 2 custodial moms. The 2 custodial moms were looking to relocate. The court simply said, sure, go ahead and relocate, because you deserve a fresh start. You're going to get a new job, you got new lovers in your life, or married partners, whatever. And so you have the right to get a new start. And nowhere in that opinion, Tropia versus Tropia, it's a relocation case, a joined relocation case involving 2 pairs of parents.
And that's it's a judge's discretion case, am I right? That
it's
they
the High
have
Court.
the ability to
Well, it's the High Court of New York, and they set precedent in that case over the standards and factors to be employed on whether a parent should be allowed to relocate with their child, sometimes physically, geographically, quite remote from the other parent. But nowhere in that opinion, and I'll challenge anybody to read it, okay? It's only a little over 10 years old, and nowhere in that opinion did they show any concern for the non-custodial parent, which, of course, statistically, 2 guys, all right? But what was even more fascinating about that opinion is they came out with what I call the Humpty Dumpty legal doctrine. Now, before you laugh, okay, it's in the opinion. It is in the opinion. The High Court of New York said that they cannot clean up the broken pieces, or the pieces of a broken marriage. And they said, and they compared it to Humpty Dumpty, and they used Humpty Dumpty in this scholarly opinion, and they said that they can't clean up the pieces left behind.
How intellectual.
But here's the kicker on it. Nowhere in the opinion did the High Court talk about who pushed Humpty Dumpty off the wall. Now, as long as they're using Humpty, I'm going to use him too.
Sure.
But they pushed him off the wall. Who pushed Humpty Dumpty off the wall? Was it the parents, or was it the state?
State.
Because they nowhere in that opinion did discuss the state's role in all of this. How they forced parents to fight over power and money awards. How they encouraged people to fight. And how do they do this? Through the lawyers. Nowhere is, and so for everybody out there, when you go to hire your lawyers, okay, remember something. When it's all said and done, the courts are going to blame it on you. They're going to come out and say, can't clean up the pieces of your broken marriage. And you come across the fool when it's all said and done. It's all your fault. It wasn't your fault. People are breaking up all the time. There's a lot of influence coming out of Hollywood in their environments, and it's not the parents' faults. Sometimes it is. Yes, there are those who abandon their children, and there's drug issues and criminal issues. We're not talking about that. My movement is about mainstream parents who simply find it better to be in separated residential environments. It's not making them bad parents. But the state discriminates.
Makes you a bad parent.
They stigmatize them.
That's right.
And they don't, and the lawyers, when they come out of this, okay, they put the blame on you. And in separate settings, they are sometimes even yelling at their clients. Read the book by Alec Baldwin, for example, A Promise to Ourselves.
I have, yeah.
He does a pretty good indictment of the legal system, and he does it nicely, okay? But I think he was trying to say a lot more. Just felt that he couldn't sell his book, or maybe he felt he didn't want to get sued or something. I don't know. I don't have any fear of that. What I'm simply saying is I describe the system as it is functioning, as it is operating, as it is affecting and damaging our parents. I'm not describing the system as they say it is. I'm not adhering to a Humpty Dumpty philosophy here. I am not accepting it when they simply tell us, declare in Section 40 of the Domestic Relations Law that, by the way, Chris, we're looking out for the best interests of your children. And that's what we're all about. Anybody could declare something,
Let's talk
but
about
functionally something else is going on. That's what I'm
Let's
focused
talk about that best interest principle, because that's something we hear all the time. Some standard that was applied, right? It's not a law, the best interest. It's a standard it's a word that's used. It's a moniker that travels.
Its origin is that 1925 opinion, Finlay versus Finlay, the Chief Justice of, again, the same High Court of New York. And they came out and said, well, you know, the state should act in the best interests of the children. But now, nowhere in that opinion did they bring in the constitutional standards, which is harm, neglect, you know, to the child, abandonment. That's the only time that the state has a reasonable or compelling reason to interfere into the parent-child relationship. It is a standard then that became codified in the present-day Section 240 of the Domestic Relations Law.
Right.
It is just a declaration. And here's what it has done, though, and you have to step back and, again, look at how the system is functioning. Not what they tell you, but what is really occurring. When they say that the state is acting in the best interest of their children, a seizure has occurred here. They've essentially said that we are taking your children because we're acting in their best interests. And you're standing here looking somewhat dumbfounded and saying, well, I guess it's in the law. Okay, the High Court said it. They even quoted Humpty Dumpty. But at the same time, you've lost your child. Okay? And you haven't even seen it take place. They snuck it out from behind you. There was never any hearing. When they said that two parents, neither of them have a prima facie right to their own children, they've seized the child without a hearing. And that violates your due process rights. And then that gets into the First Amendment. And your right to petition government for free redress of grievances, that little-known clause, the last clause of the First Amendment. And they're violating, ramrodding over it, the Fourth Amendment, the Fifth Amendment, the taking of property without compensation even. Because a parent-child relationship is property. The child may not be your property, although the state is treating it like theirs.
And then you go ahead and appeal. You go ahead and appeal, and what's the probability of an appeal being overturned? What's the number?
Rare. The percentages are small. But the problem with appeal is even if you're successful, oftentimes they remand it back for a new trial. Okay? How many people can sustain the appellate process in New York State? And here's something that no one will tell you.
I tried.
Okay.
I know what that's
here's something
like.
that the layperson does not know, and many lawyers don't even have a real grasp of this. Okay? Nobody's really done a study. As part of my lawsuit in federal court, I've asked that the federal court order a study on this, because we, the folks, can't do it. Because they protect this. They guard this multi-billion-dollar industry very well, okay? But what I've asked is that they look into it.
You've asked the federal government to oversee the state appeal process?
Well, in a sense. Well, they did that in Brown v. Board of Education. Why is that such a surprise? What did the federal government do? They went into the state educational systems, all their school districts, and they said, oh, this separate but equal doctrine, it's been the law here for many years, just like, remember, best interest of the child. They've taken the child and placed it above the parents. It's what I call the inverted and inverted parenting environment that the state has created. They've taken the children, placed them above the parents, and where is this such a surprise to hear from me? You have two parents fighting over their children and spoiling those children. And the process of becoming spoiled, they become bad adults. And so, you know, they've really damaged traditional parenting.
They're stopping us from being able to prepare our children for what we think the world will be for them out in front.
Yeah, they've turned you into a child. They've turned you into, and that's where the judges love it, because they come and say, oh, you're acting like children. You know, well, you turned us into children.
Sure, you minimize
You're making us fight over our children because we love our children so much. And in the process, we start sounding, and why not? They've made us wards of the state. They've said, we know how to raise your children.
That goes back to the adversarial process, though.
Back to the adversarial process where they feed off of this. It's a giant forensic feeding system, okay? And it's gotten completely out of control. Mainstream media hasn't picked up on this. That's what makes your program so important. But again, I want to get back to the point under New York law. Under New York law, every order, there are letter decisions now. They can't keep up with the issues, so that they're now issuing letter decisions. They kick out a letter. That's now a ruling.
That's serious.
If it involves what's quote unquote, what's called a substantial right, you must appeal that. If you don't appeal it, you will waive that right. The chances of you waiving that on appeal are very strong. So here's what you have to do. Every letter decision, every ruling, every judgment, every decree, every order, however trivial, those ex parte restraint orders where you're not even there.
Oh,
you
yeah,
have to
of course, appeal them.
And you got 30 days to do it. In the course of a highly contentious divorce, which they will inevitably make, the unsuspecting litigant,
yeah, it's
the
a plan.
intelligent ones especially,
Yeah.
they're great ones, okay, and the ones with money. You will have to appeal all those. Now, I have at least one case in which the total number of orders, judgments, decrees, ex parte and otherwise, exceed 50.
Wow.
Now, how in the world, the filing fees alone, appellate filing fees just to file is $65 now. Then you got to perfect it. You're well over $200 just up front. The transcript costs are going to get into the thousands of dollars. We're not even talking about lawyers yet. Now take all these orders, appeals, and decrees, combine all that, all the money the state's making it. Now even motions are $45. Those used to be for free. You know, your motions are just your basic, hey, judge, can you give me an extra Sunday? Oh, yeah, sure, but you got to give me $45 first. This is how bad it is and the kind of money-making system it's become. How can you possibly even talk about an appeal, Chris? So many of them, you're going to get bankrupted, and then they're going to just send it back for another new trial potentially.
You're also saying that's what we got to do. All these letters, you got to go back and appeal.
Yes.
And how do you get through it?
Or consolidate them, but you're going to just need a good appellate lawyer to do that. And I've seen some appellate briefs that talk about shocking the conscience, because I think the whole system does that, but some of the work I've seen is sorely deficient and substandard. And lawyers are so quick because they're overwhelmed. The courts are overwhelmed on top of that. Why? Because the wisdom of the whole parenting right is this. It wasn't intended to be yours to begin with. You know, it wasn't made that way whether you believe in God or not. It was inherent from the beginning of time to be something sacred and special and sensitive between mom, dad, and the child. When the state comes in, when they should not, when there's no crime being committed, when there's no serious deficiency, okay, the old days, okay, there was a family uproar, okay, you know, maybe mom and dad came yelling at each other in the streets, and then the neighbor said, oh, geez, it's, you know, Harriet and Henry going at it again.
Right.
And then he went back home, and it was the end of it. Now,
Right.
I don't advocate domestic violence, obviously. I think there's a lot of domestic violence occurring to men that's been outside the equation because they don't report these things. It's just inherent in the genetic, the way they're programmed, if you will. But there's also domestic violence occurring with false charges, and they're destroying. And when you take children away from good parents, as far as I'm concerned, the state is committing domestic violence. So we could take that definition to a lot of other areas that people don't want to go. But it's very real. Again, I talk about the way it's functioning and not the way they say it's working.
What can we do, or what can we suggest to people of families in transition that may be caught up, or when divorce might be imminent, or that flag might be sent up that something might happen? Do you have any ideas of what might be able to help avoid it? We always say, you know, before you get to a lawyer, get to someone else.
I can't say this if anything I've said made sense here today.
It certainly
I
does.
want to say something.
Okay.
That I will say. Anybody who's listening or viewing this today, stay away from lawyers. Come to consent. Find a way to do a separation agreement. Force the judge to accept it, whatever it takes. Do not go into these courts.
How do you feel about
in a
mediation?
Contentious environment. Mediation is great. Make sure the person who's doing the mediating knows a little bit about parenting, however. Okay, certificates don't matter as far as I'm concerned. Licenses don't matter. I sacrificed mine for this cause because after 25 years, it's the right thing to do. But work it out. Work it out. Talk to mom and dad. Talk to grandma. Talk to whoever you trust in your family environment. Go there first. If that doesn't work, look at your whatever religious, whether it be a church, a temple, or
family member, whatever.
And if that doesn't work, then each of you pick out a mediator. and work it out, okay? And remember what I said, a town that can't support one lawyer can always support two. So get one lawyer to walk this through, okay? That all of the T's are crossed, the I's are dotted. Finish it up, get on with your lives. Move on with your lives. Don't surrender it to the state, because they will torture it.
One of the examples I always give is that I'm a divorce mediator, and one of my divorces, all the papers that were filed and was about this thick. It was about 3/16 of an inch thick, less than 1/4 of an inch thick. They had litigated for 2 years, and the papers were about 3 or 4 inches thick. They didn't get anywhere. We solved the mediator, the resolutions in a very short period of time. I think it was about 2 months. So they spent a year or two, that much paper, thousands of dollars, thousands and thousands of dollars, and for less than $2,000 we had 3/16 of an inch of paper. Same filing, passed it along through, and they were divorced. It's a simple matter of getting together with those who you love and care for, as you suggested. Find out the amount of counseling you can get out of court.
Well, one of the things that mediation really, I think, where I think it's so much more beneficial is this. The judge, remember, is acting in the role of the parent's patriarch power. The father of the state is the traditional doctrine that sees its way into courts today. They don't come in with a neutral function or a neutral role. They believe they know what's in the best interest of your child, a person they've never met. They weren't around when that child was born, okay?
With the state
but the
behind
state
them.
has told them.
The state, that's right. I was just going to say that.
And some of these judges have never had children and maybe have miserable lives of their own. But the fact is, they don't come in with that neutral role that should be played. The parents have to be, in the first instance at least, presumptively acting in the best interest of the children, not the state. Do you see the great fallacy in all this? When you step back from it for a minute, you begin to see how everything is collapsing in our country today. It's the parents. It always has been. Our civilization wouldn't be here today if that presumption were not true. In the first instance, the parents are presumptively the best caregivers for their children. And so you mediate with the parents. The children are not involved. However, when you go into court, and particularly if you're a non-custodial parent, the first question, before there's even been a hearing, the judge wants to know, are you paying enough child support? But are you paying enough child support? Well, I'm not. You're not. You're the non-custodial parent. Well, that's because somebody had to pick the child. The child was still in the womb. Judge, what was I supposed to do? And I didn't want to fight your non-custodial parent. I don't think you're paying enough money. And then if you haven't got a job, you need to get a job. And then we impute income. And then if they take your license or something, are you driving without a license? Wait a minute. You haven't even gotten to the question of whether I'm a good. I should even have to prove to you, the state, that I'm a good parent. It's simply dividing parenting time, making sure people the main issues are taken care of. And a mediator is in the best position to do it, because unlike all those presumptions that work against the inferior parent, which should not even exist, okay, the mediator is able to look at what is in the parent's interest. Sure. And they don't become children anymore in that type of an environment.
As a mediator, what we do is we place the child at the top. We put a picture of the kids on the table. We have them discuss what their life is going to be like going forward. How can we manage their life? When we're done with deciding how the children can best be served going forward, then we decide whatever we have to within the confines of law.
Sure.
Make sense?
Yeah, the parents feel that they're very involved in that process.
Thank you, Leon Coziola. I appreciate that. You did a great job. Societal and political trends are rapidly breaking down the family that once was the cornerstone of our great American culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. Of course, we always invite opposing views. My name is Chris DiMaggio. Thank you for watching FIT TV, and we'll see you again next week.